So hi, good morning class. I wanted to provide a video, just extra support to go along with the lessons and your readings. And I just wanted to provide you with a quick additional video so that you can hear from me, hear my voice, get to see me, and just discuss this week's classwork. I think it's a great supplement, so I hope you enjoy it. If you do see me looking down, I have notes. And I just want to make sure that I cover everything and give you everything that I have on the topics. So I will jump right in, and it'll be brief. It'll just be a supplement, okay? So good morning. I am Denisha. I am your professor for this course. I'm very excited about it. I'm new to the college, so I'm very excited to engage with each of you, and you have been doing really well on the discussion board. I have enjoyed reading each and every one of you guys' discussions. So today we're going to dive right into the topic that is the foundation of everything in the legal system. It is our laws. It is the foundation, because every single thing that we do, the sources of law is relevant. It is important. So as you begin your paralegal journey on understanding the different types of law and how it works and what's binding and what's persuasive, it will help you in your research. It will help you in understanding complex legal concepts. So this is very important, and if you grasp this, it is something that you will use day to day, and understanding it will definitely help you research and write. So if you've wondered, where does laws come from? Because we have so many laws. We have, regulations there. We have, if in your towns, you have ordinances. We just have all these different restrictions to tell us, what we should be doing and what we should not be doing. So by the end of this session that I'm having with you now, I hope you are able, on top of all of your reading, I hope you are able to understand and identify and describe the major sources of law in the United States. I hope you're able to distinguish between primary and secondary legal sources. You'll understand the difference between binding and persuasive authority, as well as you'll be able to evaluate the credibility and interpret legal sources, which is very critical. So we will start with the sources of law in the United States. Where do we get our law? Where does it come from? There are 5 major sources of law in the U.S., and each one of them plays a unique role. First, let's talk about constitutional law. Our Constitution, where it all started. And this is at the top of the hierarchy. We have state constitution, but we have the U.S. Constitution, and this is the top. This is, as they say, this is the top dog. This is at the top of the hierarchy. And it's our supreme law of the land. It lays out the structure of federal government, powers of each branch, as well as individual rights, what you see in our Bill of Rights. So just think about it. It states how our government is structured. It states what power each branch of those government have. And then it also talks about our individual rights, the rights that we have. So that's a powerful document. That's why it's the supreme law of the land. And as I stated, each state has its own constitution, and that governs within the states. So for example, I'm in Mississippi. We do have a state constitution, but our state constitution is not binding on Texas or New York or California. It's binding on Mississippi. And one thing to note, our state constitution cannot conflict with the U.S. Constitution, meaning that if it's something that conflicts with the U.S. Constitution, the U.S. Constitution trumps our state constitution, so it cannot contradict. So let's jump into statutory law. That's the second thing. These are the written laws passed by our legislative bodies, Congress at the federal level, and state legislators at the state level. So these are the laws that's passed by our legislators. Examples: the Civil Rights Act or some type of state criminal code. So remember, your statutory law comes from your legislators. Here's a quick tip. If it is passed by lawmakers and then published in a code book, it's a statute. So that's a tip to help you remember what a statute is. If it's passed by lawmakers and then published in a code book, it's a statute. Let's go into the third thing, administrative law. I have practiced administrative law. And I was actually an administrative hearing officer for the Office of Inspector General here in Mississippi. And we actually had held administrative hearings for SNAP, which is the Supplemental Nutrition Program. We also did sub-grant hearings and different hearings like that, but I was a hearing officer, so I have practiced some administrative law on the state level. So administrative law, these are rules and regulations created by administrative agencies like the EPA or the Social Security Administration. We have those rules. We have to abide by those rules and regulations. For example, our agency, we receive federal funding from some of these agencies. For example, USDA, and they have their rules and regulations, and we have to follow them as it relates to that funding. That's where we get our administrative laws. So agencies are the experts in the fields. For example, USDA, Social Security, EPA, they're the experts in those specific areas. So they fill in details that statutes may leave out, because you remember the Constitution does not have everything. Statutes don't have everything. So we have administrative law to supplement that, and you get that supplementation from those individual agencies who are considered the experts. So let's go into the fourth thing, case law. Case law is just what it sounds like. It is from the courts, judges. It's also known as judicial opinions or precedent. You may hear that interchangeably. You hear case law sometimes, but I hear precedent, that's precedent, or I hear a judicial opinion. I hear that more. So if you hear case law, common law, judicial opinion, precedent, they're talking about the same things. And this is where judges interpret statutes and the Constitution, and their decisions can shape how laws are applied moving forward. So for example, the Constitution may be challenged. It may be an area that is not black and white in the Constitution, that gray area, and it goes to court, and judges, they help with interpreting those statutes in the Constitution, and those decisions are binding, and they shape how we apply the laws that we already have in place. So they create precedent. They provide a judicial opinion, and it becomes case law. We have so many landmark cases that has shaped our U.S. law, and landmark cases are just those major cases where we get those judicial opinions that changes how, processes and how we apply the law. And just to name two, Brown v. Board of Education. We have Brown v. Board of Education, Miranda versus Arizona. And we have plenty more landmark cases. Like if you just type in landmark cases in Google, you will pull up some of those cases. Just make sure when you're reading the cases, you go to a legitimate, credible site to read about it. And we'll get into that further on. So now let's get into primary versus secondary sources. Your sources are important. When you are researching, you want to make sure that you have credible sources, from reputable authors and sources, because the worst thing you can do is use a source that's not credible and the information is not correct, because you don't want anybody reading anything and it's not correct. That's the worst. That's the worst thing that can happen to you. So knowing your sources and being able to determine if it's credible is very important. And I'll tell you just how. So the first thing, primary sources. These are your actual laws, the raw legal material. So that is the Constitution, as we discussed, statutes, administrative regs, court decisions. These are binding and they serve as the core legal authority. These are this is what you will cite to. Like in your arguments and in your documents, you'll cite to your primary sources. Now, secondary sources, although it's not necessarily actual laws, secondary sources are very helpful because it helps lead you to those primary sources. It helps you understand it, because sometimes when you get to a primary source, sometimes reading a statute is difficult. You don't understand it. So you may need to go to a secondary source, a credible secondary source, to, get a better understanding. And so secondary sources aren't bad. It's just not the source that you would cite to. So secondary sources are tools that help explain, analyze, as well as critique the law. It can include legal encyclopedias, law review articles, treatises, and commentaries, statements of law. They're not binding, but they help you understand and interpret the law. So it's it's a really good source. And I normally, in my research, I will start with a secondary source to give myself some background and some understanding. It helps me with my research. It helps point me in the direction that I need to be going in. So when I finally do get to that binding primary source, I have an understanding of what I'm looking for. I can put it into words and I can search for the authority that I need to cite. So it's not a bad thing, it's a good thing. So an example, if you're researching, let's say, negligence law, a secondary source might summarize trends across the state and explain key principles. And you can use that to understand, and it'll help you get to what you need to get to in that research. So just remember the difference between the two. Remember which is binding. Remember that secondary source is not a bad thing. It's actually a great thing, and it helps you understand. The next thing we'll talk about is binding versus persuasive authority. So this is where your understanding of legal authority really comes into play. Binding authority, this is the law a court must follow. We must follow binding authority. A decision from a higher court in the same jurisdiction, statutes or constitutions applicable to the court's location. Example, a Mississippi trial court is bound by the decisions from the Mississippi Supreme Court. So remember, it's important to know what jurisdiction you're in, and that will lead you to what your binding authority is. Persuasive authority. This can influence a decision, but it's not required. So some examples: cases from other states, legal commentaries, trial court decisions within the same state. These are not binding, but in your case briefs and your arguments, it can be persuasive. It can persuade the fact finder to decide in your favor. It's persuasive. So here's a scenario. Let's say you're working on a case in Texas. You find a great case from California. Can you use it? Absolutely, you can. You can use it, but it's not binding. It's not how Texas courts have ruled. They hadn't ruled this way, but it's persuasive. The judge can consider it, but that doesn't mean they have to follow it. So remember your persuasive and binding authority when you're doing research, because a lot of times, I know from personal experience, when I'm researching an issue, I don't find much. It may run into where I don't find much authority for the state of Mississippi. So I go outside of the state and I will find authority, and I will use that to supplement what I have found to make my argument stronger. Now, the court does not have to accept that and follow that, but I use it as a persuasive tactic. So next, interpreting sources and evaluating credibility. Always evaluate the credibility of the source. You don't want to use some blog and the person is not credible. They're just giving their opinion. We want to use credible sources. So when working with laws, always ask yourself, what's the context? What is the context of this law? Laws passed during the civil rights era may have different implications today. Ask yourself, what is the intent? Legislative history can shed light on a law. So if you look at the committee notes or floor debates, it can help you understand what the intent of that law was. Is there precedent? So ask yourself, is there precedent? Has this law been interpreted already? Is this in case law where a judge has interpreted this law and told us how it should be applied? Next, is this a credible source? Stick with governmental sites, official publications, or trusted databases like Westlaw, LexisNexis. Be careful what you get your information from. I advise against going to Wikipedia, because those are people who can post different things. That's not legitimate. So use credible sites and resources. So let's just imagine you're reading a blog about a recent Supreme Court case. Would you cite to that blog in your legal memo? I would not, because it's not an actual opinion. It's not. It's not. I would look at the actual opinion and then I would cite to that. So let's do a quick recap. The U.S. legal system is built on 5 sources: constitutional, statutory, administrative law, case law, and executive orders. Our primary sources are the law. Secondary sources helps explain it. Binding authority, remember, we must follow it. Persuasive authority, we can use it, but it's not binding, and it still may be considered for that persuasive tactic. So evaluating the credibility and context of your sources is key to research. As future paralegals, your role in legal research and source interpretation will be critical. The knowledge is not just for education. It can impact the outcome of your case, the outcome for clients, the outcome for the attorney. And remember, your research represents you. So you want to produce accurate and great research. You want to show that you have checked the sources, you understand the sources, you are knowledgeable, and you are producing your best work. So when in doubt, always ask yourself, is this law or is it someone else's opinion about law? That question alone can save you from costly mistakes. I hope you enjoyed this. I am going to do this for each week. If you have any suggestions, questions, please feel free to reach out. I'm always eager to hear from you. I want to help as much as possible as you embark on this journey to your future career. All right, until next time.